Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I am able to cover a vast, diverse range of matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please feel free to get in touch. Two ways of getting in touch with us. First of all, if you want to speak to me live on air, please ring the landline number which appears at the bottom of the screen. I'll be able to have a discussion with you live on air and discuss your query with you. Secondly, another very popular way of getting in touch is to send us a WhatsApp message on the mobile number which also appears at the bottom of the screen. So landline number for direct live calls to the studio here and to have a discussion with me, or alternatively to send a message with your questions, please do that on the WhatsApp number. Text messages, WhatsApp messages, they're very, very popular, understandable, because people don't necessarily want to come on air live to discuss their legal complex issues. So that's not a problem. Either way of contacting us is acceptable to us and good for us. A couple of minor points before we get going. If when I've spoken to you, if it transpires that your matter's complex, or it looks like I need to look at your documents before I can advise you properly, then I'll ask you to leave your number with the control room and I will have a discussion with you off air. Again, it's advice that we provide completely free of charge. But in my experience, the vast majority of questions that come in, whether they're live on air or whether they are sent in via WhatsApp, I am able to give you a firm guidance in relation to those matters live on air. So please feel free to get in touch with us. Direct call to us on the landline number. Alternatively, continue to please send in your messages on the WhatsApp number, mobile number, which is there. Now, just before we came on, we've had a number of questions coming in already. So let's look at some of the questions that have come in on WhatsApp. But as always, please do continue to send us your questions on WhatsApp or live on that landline number. Now, first question that's come in is in relation to a spouse application. And the question is as follows. I am preparing to apply for my wife to come to the United Kingdom. The English test certificate expires in November. There's a date given. I think it's the 11th of November, 2021. My documents are about to be ready. They're not completely ready. Should I ask my spouse who's abroad to do another English test? So, okay, fairly straightforward question. It's an immigration question. In particular, it's to do with a spouse application where somebody wants to sponsor their husband or wife to the United Kingdom. Question is about English. My view is just hold on. If you're able to get your documents ready in the next couple of weeks, it's fine. If not, another test will have to be done because the expiry date is coming. I'll look at this in greater detail after I've taken our first call for the day. Hello, Assalamu alaikum.
वालेकुम सलाम। अनस भाई, मेरा क्वेश्चन दो है। एक ये है कि वाइफ पाकिस्तान से मंगवानी हो तो खावन की कितनी वेजेस होनी जरूरी है?
ठीक है, नो प्रॉब्लम।
तो दूसरा सवाल मेरा ये है, वर्क परमिट से जो आजकल सुन रहे हैं खबरों से, तो पाकिस्तान से आदमी मंगवाना, उसका क्या प्रोसीजर है वर्क परमिट का?
भाई साहब, जो आपने वेजेस के बारे में जो क्वेश्चन पूछा है ना, कि अगर वाइफ को बुलाना है पाकिस्तान से तो वेजेस क्या होना चाहिए, तो वेजेस के बारे में जो क्वेश्चन है ना, तो वो आप काम कर रहे हैं, नॉर्मल जो एम्प्लॉयमेंट है या आपका सिचुएशन?
नॉर्मल, वो मेरा भाई वो काम कर रहा है।
भाई का है जी, नॉर्मल। तो ये तो नहीं है ना कि उसको कोई बेनिफिट्स मिल रही है, कोई डिसेबिलिटी बेनिफिट?
बेनिफिट में नहीं है, वो फैक्ट्री में काम करता है। तो यानी मिनिमम कितनी वेजेस होना चाहिए, और क्या कि उसका पाकिस्तान लाइफ इंग्लिश टेस्ट होना जरूरी है? यानी पूरा प्रोसीजर बताना प्लीज।
जी जी, ठीक है। तो वो तो एक तो भाई की वाइफ के बारे में है और हस्बैंड जो है यहाँ आपका भाई जो है
दूसरा वर्क परमिट के बारे में।
जी, तो आप जो वर्क परमिट के बारे में जो पूछ रहे हैं ना, तो यहाँ कोई बिजनेस है जो स्पॉन्सर कर सकते हैं, ऐसा कोई किसी से बात हुई है, कोई बंदे ढूंढ रहे हैं, ऐसा कुछ है?
वर्क परमिट यस है।
चलो ठीक है, ओके, वो इम्पोर्टेंट है कि यहाँ कोई स्पॉन्सर चाहिए, यहाँ कोई बिजनेस चाहिए। तो भाई जज़ाकल्लाह, थैंक यू आपका कॉल के लिए। मैं अभी आपके दोनों क्वेश्चंस को अभी मैं आंसर करता हूँ।
थैंक यू वेरी मच।
थैंक यू, जज़ाकल्लाह आपने फोन किया। थैंक यू, खुदा हाफिज़। So the question is twofold, two different questions. One is relating to a spouse application. How does somebody sponsor a partner to come to the United Kingdom? Specifically in relation to the financial requirement. What is the income that the sponsor, the partner in the United Kingdom, has to have before they are able to sponsor their husband or wife to come to the United Kingdom? Now, in practice, the normal problem or the normal issue that arises with spouse applications, it does actually relate to finances and in particular income. Specifically, in answer to the question put to us, what is the income requirement? But generally speaking, the income requirement is that the sponsor in the UK should be earning £18,600 per annum. There are exceptions to that. Somebody who's in receipt of disability benefits, carers allowance, may well be exempt from that requirement. But generally speaking, if the sponsor is simply working in the United Kingdom in employment, and this is what our caller was saying, that the brother who is intending to call his wife over is in employment in a factory. That being the case, what he would look at is to demonstrate an income of £18,600 per annum. Generally speaking, what you do is you submit your last 6 months' wage slips. And there are rules which apply in terms of what your gross pay needs to be each month. Different rules apply to fixed salaried employment. Different rules apply to hourly paid employment. But generally speaking, what you would need to do is show 6 months of wage slips where the income is meeting the £18,600 requirement. So generally speaking, that's the starting point. Now, there are other ways of meeting the financial requirement for the benefit of our viewers who may not be in employment. It is possible to meet the financial requirement by showing rental income, by showing cash savings, by showing receipt of dividends, even receipt of student grants, etc. So there's a whole host of different ways of meeting this financial requirement. However, specifically in answer to the question put to us by the brother who called us, in answer to that specific question, the normal requirement would be income of £18,600 assessed over a 6-month period. Now, if it's a new job, there are different ways of meeting the requirement. But generally speaking, we're looking at demonstrating that there is income of £18,600 per annum. So that's the position with the minimum income requirement. The second point put to us was in relation to the English language requirement, and that relates to the first question that I was trying to answer as well. What is the English language requirement? Well, in most cases, you need to demonstrate that you've passed an English test at quite a basic level. Normally, it's referred to A1 Life Skills Certificate, one of the lowest English assessments that is out there. So it's not a difficult test, but the test nonetheless has to be passed before you're able to apply for a spouse visa. Now, as always, there are exceptions to that. So it could be that the person who is being sponsored is over the age of 65 and therefore exempt. It could be that they've got some kind of illness which prevents them from passing the test, in which case they may be exempt. But generally speaking, and in this show, all we can do is give you general advice. in relation to the questions put to us. And that's why we always say, if you're unsure, you should always seek specialist advice on this area from an experienced lawyer, because people's circumstances are different. But generally speaking, as far as the English language requirement is concerned, there is a particular test which needs to be passed, and it's normally known as the A1 life skills test. So there you go. In terms of spouses, 2 specific questions put to us. In terms of the income requirement, generally speaking, £18,600 per annum. In terms of the English requirement, yes, it does exist and it is there. Just one point that's come to my mind for the benefit of our viewers who are watching the show. There is another exemption, sometimes quite easily forgotten because we don't come across it very often in practice, is that certain nationalities are actually exempt from the English language requirement. Very limited countries. Off my top of my head, roughly about 15, 20 countries. If you've got nationality of those countries, you are actually completely exempt from the English language requirement. So it's normally countries where the official language and the language actually spoken is English. So if I take, for example, countries such as the USA, Canada, New Zealand, Australia, there's quite a few others, but generally, if it's an English-speaking country, then potentially you're also exempt from the English language requirement. That was the first part of the question that was put to us. The second part related to work permits, and what our brother who called in wanted to know specifically was how the work permit scheme worked. And we've got actually a couple of questions on that coming on WhatsApp at all. It's quite a broad question that's been put to us. We're going to be taking a short break shortly. And what I will do is, when we come back, I'll look at the situation with work permits, who it applies to, how it works, what needs to be done, give you a general idea about work permits, which are actually known as the skilled worker scheme. So once we come back from our short break, let's look at this work permit skilled worker scheme. We'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, to send us a WhatsApp message with your questions, please do that on the mobile number which also appears at the bottom of the screen. Landline number is for direct calls which are put through to me here in the studio, and I can advise you, give you a view in relation to any legal question that you have. Okay, just before the break, we had a brother who called in who had 2 questions. The first question related to spouse applications and some particular requirements in relation to spouse applications. Second question related to work permits, or what is now known as the skilled worker scheme. And the brother who called in relation to the work permit scheme, wanted a general overview, an idea about how this scheme works. Now, there is currently a lot of interest in the work permit scheme, or the skilled worker scheme. A lot of the interest has arisen, I think, for 2 reasons. First of all, the scheme has been made significantly easier to sponsor workers to come to the United Kingdom. So one is, it's much easier to sponsor people. And the second is that in the workplace, businesses are finding it difficult to recruit and fill posts which are vacant. And in my experience, at the moment, there are a lot of vacancies. Employees are moving around a lot, which is causing problems for businesses, where obviously businesses want employees to stay with them over a long period of time, and they're looking at the work permit scheme or the skilled worker scheme in order to fill that gap. They are looking at whether it's possible to sponsor migrants to come to the United Kingdom to fill posts which can't be filled at the moment, And also, I think they have in their mind the possibility that those who are being sponsored may stay with them much longer. There might be more loyalty in terms of employment. So that's why it's become popular. One is it's become much easier to use the scheme. The second is there is generally a problem with filling posts which are vacant at the moment. So work permit schemes have been in existence for a considerable period of time. Certainly over the last 2-3 decades, whilst I have been in practice, there's always been some form of scheme whereby people can come to the United Kingdom in order to work for an employer. Over the years, the scheme has changed, but in essence, the purpose behind the scheme is the same. It's to enable businesses in the United Kingdom to sponsor those who are abroad to come to the United Kingdom to work for them. It's a work visa linked to a particular employer. So over time, the scheme's changed, but the concept has always been the same. In essence, what you need, the starting point is this, that there has to be a business here in the United Kingdom, or has to be a charity, has to be an organization, an employer that has to obtain a license from the Home Office. And you would have heard this term mentioned quite a few times, that it's a sponsorship license which is obtained from the Home Office. And the Home Office, before they issue a sponsorship license, will carry out certain checks. The Home Office will want to know that the employer is genuine. Home Office will want to know that if the employer was to employ somebody from abroad, that they have proper systems in place, that there's proper HR systems in place in terms of recording absences, holidays, pay, etc. So they're looking at whether the business is genuine. They're looking at whether proper systems are in place. They're looking at also whether the business has a genuine need for the employee. So they want to make sure the scheme is not being abused. It's not being used simply as a means of people coming to the United Kingdom. So an application is made to the Home Office in order to obtain a sponsorship license. An online application is made. There's a fee of approximately £500 which is paid. Certain documents are submitted to demonstrate that this is a genuine business. So essentially, the Home Office is looking at whether the business is genuine, whether they've got the capability in terms of HR procedures, etc., to employ somebody. They also are conscious of the fact that there shouldn't be any abuse of the work permit scheme. Let's say that's all done properly, and the employer manages to obtain a sponsor license. That's the first step out of the way to get the sponsor license. Once they've done that, it is then possible to approach the Home Office and say, look, we have identified this particular person who we wish to employ. And what is then requested is a certificate of sponsorship in order to employ that person. So the first stage really is the business and registering the business. That's the first stage. We then move on to normally identifying the employee who we as a business want to sponsor, and asking the Home Office essentially permission to sponsor that particular person. Now, even at that stage, the Home Office may raise numerous queries. They might have given a sponsor license, but when it gets to the second stage, when we're looking at saying, look, this is the particular role which needs to be fulfilled. Let me give you an example. Supermarket which wants to employ a butcher. So we're focusing on that. The business manages to identify somebody that it wants to employ. So the Home Office will ask questions about that, about the job, about how big the business is. Is there a need for that particular role to be fulfilled? So at the first stage, the Home Office has been satisfied as to the genuineness of the business, generally speaking. At the second stage, they are specifically looking at whether there is a real need for this employee that you're wishing to sponsor to the United Kingdom. So that's really what they're doing at the second stage. So that's what we're doing. Now, once you've done that, once you've made a request for that particular employee, the Home Office hopefully then approves that request. The last stage is then for the employee who's been sponsored to apply for a visa to come to the United Kingdom. So there's a 3-stage process. Applying for a sponsor license, registering with the Home Office. Secondly, asking the Home Office specific permission for the particular person that you want to employ. And thirdly, the person who you want to employ making a visa application to come to the United Kingdom. So in essence, that's how the work permit scheme works. It's significantly easier to sponsor somebody to come to the United Kingdom on a work permit now. Fundamental changes were made to the scheme in January 2021. So as a business, if you are looking to employ foreign workers, now is a good time to look at that and get your systems in place, processes in place, and get your application in. So I hope that answers your question. Now, had a number of questions coming in on WhatsApp, so let's just return to those questions. Now, one of the first questions that came in this morning relating to the English language requirement, where somebody is making a spouse application. They're calling their husband or wife to come over, and we want to look at the English language requirement. But we have a caller who's been waiting a while. So let's go to our caller first. Hello, assalamu alaikum. Hello.
Hello, assalamu alaikum warahmatullahi wabarakatuh.
जी वालेकुम सलाम जी.
मैं पूछनी है, मेरी हमशीरा है तो उसने कोई बाल बच्चा नहीं, कोई मर्द नहीं, कि उम्र नहीं है ते उस सदामा तक करो साहब उसी पुलिस.
जी 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 क्या पूछना है? सॉरी, आपका आवाज नहीं आ रहा है प्रॉपर्ली क्लियरली.
मेरी हमशीरा है ना
जी,
उसने कोई बाल बच्चा नहीं, कदे की नकार कदे दुए नकार, मर्द भी नहीं ते लड़ोस नहीं है, तो मैं आनी उसे बुलावा तो किस तरह बुलावा?
सॉरी, किसको बुलाना चाहते हैं आप?
जी हमशीरा को.
किसको?
हमशीरा को. उसको कोई बच्चे नहीं
जी,
उसको कोई हस्बैंड नहीं
जी,
उसमें कोई भी नहीं.
ओके
कभी किसी ने कहा, कभी किसी ने कहा लटक गए.
ओके, तो आप किसी को बुलाना चाहते हैं, वो किस टाइप ऑफ वीजा पे बुलाना चाहते हैं? विजिट पे क्या करना चाहते हैं?
उसे बुलाना चाहती हूँ ना मैं अपने के किकर बुलाऊं. बेटा है ना मेरा.
जी,
काम करता है.
जी जी
जी.
ओके, सो आपका बेटा किसी को बुलाना चाहते हैं ना?
जी जी. खाला का.
किसको? खाला को
आंटी को.
खाला को, जी जी, आंटी को, जी, आपकी सिस्टर को, जी. तो वो तो विजिट वीजा पे ही बुलाना पड़ेगा ना उसको, विजिटर पे बुलाना पड़ेगा. वो उसको परमानेंट वीजा तो नहीं देंगे, वो परमानेंट नहीं देंगे. वो उसको विजिट पे बुला सकते हैं, ट्राई कर सकते हैं आप. वो शॉर्ट वीजा देंगे ना उसको, 6 मंथ की वीजा देंगे विजिट करने के लिए. विजिट करने के लिए वो कभी आए हैं वो यूके?
नहीं आए.
कभी नहीं आए.
वीजा नहीं देते
जी, और वो परमानेंट नहीं देंगे उसको. वो अब विजिट पे ट्राई.
पक्का वीजा चाहते हो?
जी,
उसका कोई नहीं है ना, कोई बेटा नहीं.
मैं समझ गया. मैं आपकी बात समझ गया कि वो अकेले है वहाँ.
उसका कोई भी नहीं ना, कभी किसने कहा लड़ती है.
जी, नहीं समझ गया. मगर वो तब भी वो परमानेंट नहीं देते. वो सिर्फ अब विजिट, वो यहाँ का जो लॉ है ना वो काफ़ी स्ट्रिक्ट है. वहाँ कोई अकेले है, यहाँ अकेले है, मगर वो परमानेंट वीज़ा नहीं देते. आप फैमिली मेम्बर्स को विजिट पे सिर्फ बुला सकते हैं, विजिट वीज़ा पे. तो आप वो ट्राई करो. अगर आपका बच्चा यहाँ है, वो काम कर रहा है, तो वो उसको स्पॉन्सर कर सकता है. वो कह सकता है कि मैं, जो खाला आएगी आपकी सिस्टर, तो वो खर्चा निकालेगा, वो घर में वो आप दोनों रखेंगे उसको यहाँ. तो आप विजिट वीज़ा पे ट्राई कर सकते हैं, विजिट वीज़ा, मगर परमानेंट ट्राई नहीं कर सकते. आप विजिट ट्राई कर सकते हैं. जी
Thank you very much.
Thank you. आपके कॉल के लिए thank you very much. Okay. Assalamu alaikum. There was a caller asking a specific question in relation to calling somebody to the United Kingdom as a visitor. And as I understood the question, I think the caller was saying that ideally they'd want the family member to come on a permanent basis. And what I advised was the only option is probably to sponsor on a visit visa. I'll look at this in greater detail after we've come back from our short break. We'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Or as always, you can send a message on the mobile number which also appears at the bottom of the screen. We've got a caller who's been waiting from just before the break. So let's go to our next call. Hello, assalamu alaikum.
Hello, well, Islam. Just wanted to ask a question regarding my wife's spouse visa.
Okay, yeah, sure.
So basically, my wife's come over as obviously a spouse on a spouse visa, and is coming up for a renewal next year. But obviously, my circumstances have changed, and I'm actually applying for housing benefit. So as far as I've been told that she wasn't entitled to any benefits, which I've made the local council aware of this. But will it affect anything? Obviously, because it's coming up for renewal next year.
Okay. So what you've got to remember, brother, is although your wife isn't entitled to benefits, you are entitled to benefits. Although your wife isn't entitled to benefits, you are entitled to benefits. You are in your own right. So you can claim universal credits. You can claim housing benefit. So you're entitled to benefits. It's a common misconception that you know the husband and wife can't claim benefits. Of course they can, because you're entitled to it. You'd be entitled to universal credit, housing benefit. You'd be entitled to child benefit as well. So that's not a problem.
Okay, so it shouldn't really affect the spouse visa when the immigration review it again next year in July.
No, absolutely not. But what you need to remember, is if you're in a situation like the vast majority of people where you need to show an income of £18,600 per annum,
that's correct.
Then you're going to have to earn that from January to June. In order to apply in July. So at the moment, let's say you're not working at all, not a problem. But let's say you start working in January. But even when you start working in January, you're on a salary of £20,000 a year. But because of your circumstances, you get universal credit. That's fine. There's nothing that says you can't get universal credit. As long as you meet in the last 6 months, in the last 6 months,
so they don't actually look at other procedures. So even if I don't work, obviously from now up till January, that wouldn't affect anything.
It doesn't matter at all. But this is a question that comes up regularly in practice. People seem to think that they'll assess you over 2.5 years.
That's what I was under the same impression, to be honest, that it will affect.
There's so many people out there struggling, not claiming benefits because they think it's going to have a detrimental impact on their partners. No, it doesn't. You cannot work if you're unable to find work, and if you don't work until December, it doesn't matter. But they do assess the last 6 months. So you need 6 months
of scenario. Do you know if, like, I've been working for the last 3.5 years at the same employer and everything else, but worst scenario, if that affects or end up leaving a job, or they end up circumstances I've not got the job anymore because of obviously all this pandemic going on. So will that affect? So her review's coming up in July. So will that affect that? Do you think they will extend it, or will they end up sending it back in that respect?
You have to be careful because there could be problems. So we can't dismiss that out of hand. Do you have any children at all? Do you have any children?
Yes, one child.
So, well, look, the position is this, that if you have children, then generally speaking, your wife will be granted a visa. More or less 99%, she will be granted a visa. So let's say,
regardless if I've got issues with that 18,000.
Yeah, absolutely. Regardless of the income requirement, your wife will be, in 99% of cases, it's just the way it works. The specific rules which deal with this, your wife will be granted a visa because you've got a child that's British. Now, but there is an issue here. What they will do is place your wife on a 10-year route to settlement.
Right. Okay.
So at the moment, she will be on a 5-year route to settlement. So
that's correct.
Once she's been in the UK for 5 years, she's eligible for indefinite leave. If there's a problem with your finances, they will grant her a visa. So don't worry about that. But they'll put her onto a 10-year route to settlement. So essentially, she'll have to wait 10 years from when she came to the UK to apply for indefinite leave to remain. That's the big...
So it's not like they would extend it till rather than review up in July next year when it is up originally.
No.
So they wouldn't just extend it till the end of the year and say, right, we'll have a look.
No. So you know their extensions, they're always 2.5-year extensions. So it's always a block of 2.5 years. So when your wife's come to the UK, she's got a 2.5-year visa. At the extension stage, whatever happens, whether it's the normal 5-year route or there's a problem on a 10-year route, the visa will be extended for 2.5 years again. So obviously, if she's still on the 5-year route, next time round, she'll qualify for indefinite leave.
Sure.
If she's on the 10-year route, she will continue to extend for 2.5 years till she's got to the 10-year.
That's correct.
Is that okay?
No, understandable. No, thank you very much for that.
No
and is it okay if you just ask one more question?
Yeah, of course you can. Of course you can.
So basically, the other question was that obviously my missus wanted to get a mother to come across next year because we're expecting. So at that point, what's the criteria for the mum to come across just to help out and everything else, seeing as though I'm working and everything else?
So what you can do is you can sponsor, you and your wife together, you can sponsor your mother-in-law's visit to the United Kingdom. The process is relatively straightforward. As far as the UK is concerned, you would normally demonstrate, you're British, wife's here on a spouse visa. The reason she's coming here is because wife's expecting, just basically help out for a couple of weeks, couple of months. Absolutely perfectly acceptable reason. You've got money coming in, you've got savings, and you've got accommodation. So you're able to sponsor your mother-in-law to come to the United Kingdom. Dead straightforward as far as the UK is concerned. But the problem is this. The problem is that visitor visas don't have a very high success rate in practice. The reason for that is everything might be perfect your end. You're British, wife's got a proper visa, you're working, you've got savings, you've got a genuine reason why she's coming here. It ticks all the boxes. The problem is, in reality, they assess mother-in-law's circumstances in her home country. So the kind of things they're looking at is, what's her income? What's her savings, or what's her family income, family savings? Has she got assets? What has she got to go back to? So the problem is that's what they're looking at. I don't know whether, brother, you're still there or you're cut off. The call's dropped, unfortunately. But let me answer the question. It's a very straightforward question. So, in essence, what I'm saying is that from the UK, it's absolutely fine. The problem is from the home country. It's demonstrating, in reality, what the Home Office is looking at is the applicant. Does the applicant have the intention to return to their home country after their visit to the UK? So that's what they're looking at. Do you, the applicant, have the intention to return to your home country? The way they assess that particular question is to look at how strong are your ties to your home country. So have you got stable income? Have you got savings? Have you got assets? Have you got family? Have you got children under 18? Those are the factors that the Home Office will look at in assessing whether somebody has sufficient ties to their home country, and according to them, whether sufficient ties means there's an intention to return or not. So in practice, with visitor applications, you can always get things perfect. Sorry, brother, I think you got cut off as I was talking. I don't know whether you heard the rest of what I was...
To be honest, I didn't hear it. This one, I just ended up calling back.
All right, okay. So what I was saying is that from the UK, it's straightforward. The problem is from your mother-in-law's home country and her circumstances. They are looking at what her ties are, what will make her go back. So there's a lot of work that needs to be done there they shouldn't take a visitor application lightly. You need a proper lawyer, a proper agent who'll do a lot of work, who'll demonstrate what mother-in-law's circumstance. I mean, is she married or?
To be honest, the mother-in-law over there, she's a housewife, and obviously the father's like more or less retired, and he's got issues, so for that reason it doesn't work and everything else. But obviously they've got sons who look after and bring the money and everything else. And correct me if I'm wrong, I've been advised by like a family friend that ideally the mother-in-law needs to have 40,000-50,000 like more or less rupees coming into the account every month, as well as showing a strong background that she will end up going back to Pakistan after that.
But the only issue is this: if we say mother-in-law's got money coming in, you'd have to demonstrate where that money's coming in from. So if mother-in-law says, "Look, I've got 40,000 rupees coming in," then is it rental income? Is it a pension? Is it money from some other investment, like a fixed deposit scheme or something? So the problem always sometimes is about exaggerating one's financial circumstance. So whatever is said has to be backed up. If you don't back it up, it just gives them a very easy way of rejecting the application. So you have to really think about, look, and give it time. There's time to prepare. If you're going to say that she's got rental income, for example, then get the money coming in regularly every month. Get some proof that the property is owned by them. Get a tenancy agreement in place. If we're saying that there are sons there who are working, let's show their financial circumstances. If there are children under the age of 18, let's demonstrate that. If there's assets, so a lot of work needs to go into demonstrating this.
I mean, my mother-in-law's brother, he helps as well quite a lot, because like I said, given the circumstances that she's a housewife and the father-in-law can't work, so due to eyesight problems and everything else. So would that be an issue where it comes from? Because my mother-in-law's brother does help each month.
Ideally, I would say, in my view, it should be one's own family, as in they could say they live with their sons and the sons have good financial circumstances. That would be better than saying somebody else outside. I know it's family, but somebody else helping. So look, if it's the case that you're going to call mother-in-law next year, try and address that now. Look at what income are we going to show. Look at, is it their own? Is it the son's income? Assets of the family? Try and look at how you can demonstrate the strong links. From here, it's not a problem. It's just from there that there's an issue.
From there, it's more or less from Pakistan, and my mother-in-law needs to show obviously strong financial situation, background, and then family ties that she will end up going back. Is that correct? That's
essentially it. It's the strong ties. But unfortunately, there is a high refusal rate. There's no appeal against that. Very limited way of challenging a refusal. But you really need to focus on the Pakistan circumstances of mother-in-law.
Right.
Brilliant.
Okay.
Brilliant.
No, that's great. Many help. Thank you for your advice.
No problem. Thank you very much, brother, for that call. Thank you very much. Taking a short break. We'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, as always, a popular way of getting in touch is to send a message on the mobile number, a WhatsApp message on the mobile number, which also appears at the bottom of the screen. So to speak to me live on air, which is always good to hear from our viewers out there, so please do get in touch with us and give us a ring on the landline number. Now, as always, we've had a number of questions coming in. Let's look at the next question that's come in. Next question is, again, an immigration law question. The question that's been put to us is as follows, that would you be able to please explain the duration for which the English certificate and the TB certificate is valid? I am sponsoring my husband from Pakistan to come to the United Kingdom. Now, common question, and the slight confusion is that there is two different types of validity dates for those certificates. As far as the English certificate is concerned, it's valid for 2 years. So when you sponsor your partner to come to the UK, they will need to demonstrate ability to speak English, and that certificate that they submit is valid for 2 years. However, when it comes to that TB certificate that you have to submit as well for your husband or wife who's coming to the UK, that's only valid for 6 months. So in practice, what I always advise clients is that, you know what, when you're getting your documents ready, get the English certificate done, obtained, out of the way. That's going to be valid for 2 years. No problem there. When it comes to the TB certificate, you're making the spouse application, you need the TB certificate. When it comes to that, what I normally advise is that let's wait, hold on, and get that done closer to the date when we are applying, because that's only valid for 6 months. So English certificates are valid for 2 years. The TB certificate is only valid for 6 months. So there's a different validity period for those two documents which are submitted from abroad. Hope that answers that question. Okay, next question that's coming from Brother Shabs, quite a long question. Brother says, Assalamu alaikum, I got married to my husband. There must be a sister who's texted in then. I got married to my husband who is an asylum seeker. He has been in the United Kingdom for 18 years. I was born here. He's originally from Bangladesh. He's been in the UK since 2003, so 18 years in the United Kingdom. Husband's asylum seeker application was refused. We've appealed the decision. It was not in our favour. Okay. I would like to point out that we have no children of our own, so we are not sure if the appeal will be in our favour. What could we expect from the appeal? I should say, sorry, Sister Shabs, who's sent that question in. Very clear question, given us a lot of the information that we need. Fantastic. Sister says, got married to a husband who is an asylum seeker who has been in the United Kingdom for 18 years, originally from Bangladesh. So 18 years in the United Kingdom, originally from Bangladesh. Asylum applications been refused. Have appealed against the decision, as the asylum decision was not in their favour. What will happen? Look, when the hearing comes along, the hearing will look at two issues in my experience. First of all, it will look at whether the asylum claim should succeed or not, whether their husband qualifies for refugee status. I don't want to be too pessimistic, but generally speaking, I suspect it might be difficult to succeed under the asylum route. It looks like, we don't have the full facts, but it looks like the asylum application has been made quite a long time after your husband's come to the United Kingdom. If you're at the appeal stage now, and I suspect it's taken about 2 years for the asylum application to be processed, decided, and to be refused. And the husband's been here for 18 years. I suspect the asylum application has been submitted 16 years down the line. Very difficult. I mean, I don't know the ins and outs of what's happened, but I suspect it might be difficult to succeed on the asylum application. Now, as far as the asylum application, the appeal against that is concerned, let's say the judge is not with you on that and doesn't accept that this is a genuine claim, late claim, whatever, doesn't accept genuine claim. The Home Office will also look at, the tribunal will also look at, assuming this is before the tribunal as well, tribunal will also look at the human rights angle to the appeal as well. And there we've got a number of factors. You've both been together. I don't know how long, but you've been together for a while. Husband has developed a private life in the United Kingdom, spanning some 18 years in the United Kingdom. So there is something there to go on. However, the problem is this. In general terms, the position seems to be this, that if you don't have children, then your husband needs to have lived in the UK for 20 years before the Home Office will grant a visa under the long residence rules, and before the tribunal will allow an appeal on human rights grounds. Now, I know you're together and there is a family life there, but the problem is that where there are no children, generally the Home Office will say there's nothing that prevents your husband from going back to Bangladesh. I know you're saying he's fearful of his life, and that's why there's an asylum application pending and asylum appeal pending. But if the asylum appeal is dismissed, on the human rights front, in terms of both of you living here together is concerned, the approach that the tribunal may well take is that, yes, there is a genuine relationship. Yes, your husband has lived in the UK for 18 years, but in the absence of children, there's no reason why your husband can't go back and apply from Bangladesh and come back. Now, what I would do is this. Let's say you carry on with the appeal and it's refused. So I'm not sure when the appeal is, let's say in the next few months, you would be able to appeal against that decision. You'd also be able to and ask for permission to appeal. If that's turned down, you can go on to the next stage. So there are a number of other stages that you can go through if there is a negative decision from the tribunal. What that will do in practical terms is, if your husband's been here 18 years, by the time that these appeals have been exhausted, husband would have been here for approximately 19 years. Now, the key point is that at the 20-year mark, he's eligible for leave to remain in his own right anyway. So he's not that far off at that stage from qualifying for a leave to remain based on 20 years residence. So this appeal that you're pursuing, we don't know enough about it, but it may well be that it's a bit of an uphill struggle. By the time it's dealt with, by the time the appeals that you are able to lodge are all lodged and concluded, I suspect your husband's going to be very close to having completed 19 years, or he'd be at the 19-year mark. He will only be short in terms of a year from the 20-year mark. So he will, once he reaches the 20-year mark, be eligible to apply for leave to remain if he continues to reside in the United Kingdom. So I think all's not lost. Carry on with this process. Let's see where you get to. Who knows? You might get a sympathetic judge. On a good day, with a bit of luck, it may be that the judge says, you know what, you have been here for 18 years. There are some compelling circumstances. There may be compelling circumstances that we've not heard of. I don't know what your circumstances are. Let me give you an example. Compelling circumstances could be that somebody's ill, you're ill, or there's a family member that's ill, that's been looked after, etc. So there may be something there that will make the case a little bit more exceptional, where you could convince a tribunal judge to depart from the norm, which is to say, you need to complete 20 years before you qualify under the long residence rule. There may be something there. But even if there isn't, you have started this process, so try and complete it. Let's see where we end up. And as I have said a couple of times, and as I'm sure you've been advised, once your husband does reach the 20-year mark, he qualifies at that stage under the long residence rule anyway. Now, the other good thing about pursuing this appeal, even if the appeal is unsuccessful, if the judge makes a specific finding that your husband did come to the United Kingdom in 2003 and he's been living here in the UK since then, if the judge says, I've looked at the evidence, I am satisfied that your husband came to the United Kingdom in 2003, has been living in the UK since then, that's going to help you, even if in a couple of years' time, your husband makes an application under the 20-year route. It'll help you because you'll be able to show that to the Home Office and say, the judge has already accepted he's been here for 18 years. So the Home Office will find it difficult to turn around and say, oh, we're not satisfied whether he's been here for 18 years or not. He might have gone back, not gone back. It'll be more difficult for the Home Office to argue that. So some good could come out of the appeal. If you might get a negative decision on the asylum, on the human rights, but if the Home Office judge accepts the husband has been here for 18 years, that could assist with any later application based on 20 years residence, which could be made in 2023. So I don't want to be too negative, but that's the way I sort of assess your matters based on the limited circumstances that we've been provided. Hope that answers your question. And as always, if you're not sure or if you want a second opinion, you please do feel free to get in touch. Either send us a message. You can even, send us a copy of your refusal letter. More than happy to look at it. Or as always, you can give me a ring, speak to me live on air. Interesting question. Thank you very much for that, and hope I've answered it to your satisfaction. So there you go. That's the position with overstayers. And to be quite honest, in practice, immigration lawyers will have a lot of people come into the office for advice where there's no children. They've simply overstayed in the United Kingdom. They may have a partner, not have a partner, but they've overstayed. Your options are unfortunately limited. But that's where we are. Unfortunately, that's bringing us close to the end of the show. Inshallah, we'll be back next week at the same time. But thank you very much for all your calls and messages today. Assalamu alaikum.